And thank you. Good afternoon, everyone, and thank you for joining us for this webinar on immigration updates. Thank you so much to our colleagues in the CSU and Community College system for inviting us and for their partnership. We are with the Immigrant Legal Resource Center, a national clearinghouse on immigration law and policy, and we're here to provide you with some updates on some hot topics in immigration right now. I'll walk you through our agenda in just a moment, but let me introduce who the speakers will be today. My name is Allison Davenport, and I'm an attorney with the Immigrant Legal Resource Center. I'm joined with two of my colleagues, Ariel Brown and Veronica Garcia, special projects attorneys with the Immigrant Legal Resource Center. So you'll be hearing some different voices. Hopefully that'll keep things interesting for you throughout the next 90 minutes. Okay, next slide. Just to give you a preview of what we're going to be covering today, we picked kind of three topics that are in the news a lot right now and are subject to a lot of changes and confusion. The first one is the Deferred Action for Childhood Arrivals program, or DACA. My colleague Veronica is going to walk us through some updates on that program. I will be giving some updates and kind of the landscape right now with a program called Temporary Protective Status, or TPS. So we'll spend a few minutes as well talking about that program. And then Ariel will be describing what public charge is, what it isn't, who it impacts. We know there's a lot of different information out there about what public charge is and what it might mean to individuals and their families. So hopefully this will clarify some of the questions you might have. And then we're going to reserve, so those updates will take about no more than an hour, and we're going to reserve at least the last half an hour for questions and discussion, and Alonso is going to assist us with that process, so we're sure to address any questions that are coming up for a lot of you, or if there were any gaps in the information we presented, or there's other issues you'd like some information about. Given this kind of public forum and the fact that we can't really have a more in-depth conversation with you, it might be difficult for us to answer case-specific questions, but throughout the webinar slides, we've provided links to different resources that will hopefully give you some suggestions for additional information, as well as organizations that can provide you with direct legal assistance with those case questions. Okay, so with that, we'll go ahead and dive right into our first topic, and that is going to be DACA. So if we can go ahead and advance to the next slide, and I'll turn it over to Veronica.
Thank you, Allison. So I'm going to give a general overview of DACA. So DACA is a program that's been around for a while now, but there's been a lot of changes in the last few years with this new administration. As many of you may know, DACA, or Deferred Action for Childhood Arrivals, is a program that allowed certain individuals who met certain requirements to get protection from deportation. Next slide, please. So DACA was announced and implemented by the Obama administration in June 2012. Like I mentioned before, it offered protection from deportation on a 2-year period with the possibility of renewal for individuals who met the requirements. This allowed individuals who had DACA to have a work permit, the ability to get a state license or ID, and a social security number. This program has protected over 700,000 individuals to date. You know, and that's what DACA is. What DACA is not, and I just want to mention briefly, it's not legalization, it's not a green card, and it's not a pathway for citizenship. I know there's a lot of confusion in the community as to what this allows individuals to have. Next slide, please. So, like I mentioned, DACA has had a lot of changes in the last 2 years since the Trump administration entered office. So DACA was ongoing since 2012. In the fall of 2017,
on this webinar if you want to.
In the fall of 2017, the Trump administration terminated DACA for individuals, and they were going to allow the program to phase off. In the beginning of 2018, a court injunction allowed the DACA program to continue just for renewal applications. And we'll go a little deeper into who is eligible for DACA now under the court injunction. And for a while, the Trump administration had been asking the Supreme Court to hear the DACA case and decide whether the program would be allowed to continue or not. This finally happened this fall of 2019, November 12th. Oral arguments were heard by the Supreme Court, and now there's a pending decision waiting on what the Supreme Court will decide to the program. And it's good to know this because there's been a lot of up and downs with DACA. There's been a lot of changes, and a lot of people are, tired of the changes, unsure of what's going to happen next. But it's important to know that a decision will be coming sometime in the spring of 2020, definitely by June 2020. And that will be, sort of like a final decision, since the Supreme Court is the last court, here in the United States that can make a decision on a program. Next slide, please. So who is eligible to apply now as the program, as it exists now and today? All right, so any individual who has had DACA in the past, either, previously granted DACA, can request a renewal, right? This means everybody who is currently holding a valid, DACA status, right, a valid work permit. It means anybody whose DACA has expired in the past, right? So someone who might have not been able to renew due to the filing fee or other circumstances, or those individuals that had DACA, but it was terminated for some reason by USCIS or ICE or by the government, right? So I think takeaway from this is anybody who ever had DACA is able to submit a renewal right now. Next slide, please. Right, and those who are able to submit a renewal now, right, their applications will be considered so long as they meet, some basic requirements of having previously been granted DACA, having been here in the country since August of 2012, unless they were able to leave on advance parole, continuously resided in the United States, and haven't been convicted of any disqualifying offenses. Next slide, please. All right, so what does this mean, right? We're gonna look at some examples right now. So for example, let's say you or someone you know is like Betty, right? Betty was granted DACA in 2014, and she has renewed every 2 years or every time her work permit's about to expire. And right now she's currently has DACA for 10 more months, right? Betty would be able to renew under this new, under the new parameters of the program, right? Because she's someone who currently is holding DACA or was previously granted DACA, so she could submit a renewal. Betty's application would be pretty straightforward. It would just require her to submit the application for DACA itself, as well as a work permit application, and pay the $4.95 filing fee. Right, now let's look at someone like Joe, right? If you know someone in Joe's situation, right? He was granted DACA in 2015, but was unable to renew before his DACA expired in 2017, and now he wants to renew, right? Let's say Joe was unable to meet the filing fee, or it slipped, he had to move and he couldn't submit an application, but now he's ready to do it. Joe would also be able to submit a DACA renewal. At the moment, his application would be different than Betty's, right? Betty is just a straightforward renewal. Joe, because he has been, his DACA expired more than a year ago, he would have to file what is considered an initial renewal. This means that he just has to submit more proof, show that he meets the initial eligibility requirements, and show that he's been continuously residing here in the United States, submit the application, and submit also the $4.95 filing fee. Right, let's say that Joe, instead of his DACA having expired, it had been terminated in 2015 because of certain circumstances. He would still be able to renew now because he was once granted DACA, The only difference in that case would be that he should, they should all go talk to a legal rep before they submit an application. But if someone's DACA has been terminated, they should definitely go into a consult to see, why their DACA was terminated and to see how they could go about renewing now. Next slide, please. Okay, so I think this is the biggest question in the community is when should we or when should someone renew? Like I mentioned, there's a court case pending in the Supreme Court, a decision pending in the Supreme Court. It's really uncertain what the court will decide, if the program will be allowed to continue and how we know it now, whether it will change, whether it will be terminated once again. Right, so people are wondering how early they should submit renewals or if they should even submit a renewal, right? So, if you are a DACA holder or know someone who has DACA and their, DACA expires in 6 months or less, I would definitely say to go and renew ASAP. Figure out which agencies in your area could help you fill out the application. Processing time right now for DACA is taking about 5 months, so you want to make sure that you are not, there's no lapse in your DACA of time when you're not protected, so you want to do that. Right. The bigger question is for those whose DACA expires anytime in 2020, right? It is recommended that you renew your DACA every 5 to 6 months, right, before it expires. But what if you have more than that time, right? Because of the uncertainty in what's going to happen, we are recommending that anybody whose DACA expires in 2020 also renew now. And, make sure that that application gets in case a decision, from the Supreme Court does come sometime in spring 2020. It's better to have your application in than not. What about those whose DACA expires in 2021, right? There, you would have to decide whether it's worth it, right? When DACA is approved, right, or you're granted again, they start the new time period from the time that you are approved, not from the time that your old approval, would expire, right? So you have to see how much more time that allots you, right? And whether it would give you enough time that it would make it worth it to pay the $495 filing fee. Next slide, please. Sorry, previous slide. So I know that's a little confusing, right? So what does that look like? And we're going to look at some examples on what does that mean, right? When you submit your DACA and when it's granted, right? So let's look at Maria's case. So Maria's DACA expires in June 2020, right? If she were to submit her renewal now, December 2019, right? And it was granted in May 2020, right? Process, she gets a new letter in the mail saying that she's been granted again, right? This would give her protection from roughly May 2020 to May 2022, right? And Maria's in that time period where, she should renew now, so there's no lapse in time, right? She would get almost a full 2 years again, right? Give or take a few months. What about Sandra, right? Sandra's DACA doesn't expire until December 2020, right? And let's say that because of the, she knew that the case was being heard in the Supreme Court in November, and she wanted to make sure that at least she would get another year of DACA before anything changed in the program, right? So she submitted her renewal in October of 2019, right? It would take a few months to process, and then she would be granted, let's say, her DACA in January of 2020. Here, her new period would run January 2020 to roughly January 2022, right? So there, you could say Sandra's losing about a year in her, a year, but she's gaining another year, right? And since a decision might come out in June of 2020 from the Supreme Court, right? At least there she's guaranteeing that she has a bit more time, right? And, in Sandra's case, it would be worth it for her to, submit her renewal possibly because, like I mentioned, we don't know how the court will decide. We don't know what's going to happen with the DACA program in the future, right? If applications are pending, right, when the decision comes out, depending on what that decision is, there's still a possibility that it will they would make a decision on it to grant another time period of DACA. It's also very likely that the government, if the program is terminated, that they would allow permits to expire on their own, right, phase out the program. So it would be, it'd be good to add another year to of DACA protection. Next slide, please. Okay. And what if you're still unsure, right? There's a lot of news around, what administration is doing related to immigration policy. There's a lot of news around enforcement, right? And people are hesitant about submitting applications and giving information, right? Like I mentioned, if you're still unsure, it's worth considering to remain in DACA status and to file a renewal before any of the litigation cancels the program, just in case it grandfathers you into another, hopefully more permanent program. Also, all the newer USCIS policies that are placing people, or potentially there's the danger of placing people in deportation proceedings. They do not apply to DACA applicants, right? Information is still being protected from there. And there are currently a lot of agencies in the state of California covering filing fees for DACA recipients. So if you're in a situation, or someone is in a situation where they can't cover filing fees, or aren't sure whether they want to, $495 is a lot of money to put up, there's definitely agencies who could help with that. Next slide, please. And then just to quickly note, when you are renewing your DACA or preparing to renew, it's always important to have a copy of your previous DACA whenever possible, just to make sure that all information is consistent. And, if you are renewing and your DACA hasn't expired, you don't need any other evidence besides that. Next slide. So that's DACA, right? It's uncertain. We don't know what's going to happen. So what else can you do while you wait to hear what the fate of the program will be? Next slide, please. All right. We are, encouraging all individuals who have DACA, or even if you don't have DACA, to get a legal consultation. As a DACA recipient, you might be eligible for another more permanent immigration benefit. Like I mentioned in the beginning, DACA doesn't give you a pathway to citizenship. It doesn't give you a green card, right? And a lot of studies have shown that more than 20% of those DACA eligible individuals are found to be eligible for another relief. So it's important to get a consultation to see if you would qualify for something else. Next slide, please. Right, getting a legal consultation would allow you to explore other forms of status, right? Immigration, situations and the law might have changed since you last got a consultation. I know initially when people applied for DACA, a lot of people were getting screened to see if they qualify for something else. But since then, people have renewed more than once, more than twice, and often just fill out the renewal. They haven't spoken to a legal rep since maybe that first application, and things change in your own case, right? We like to say, like we go to the doctor every year, you should get a legal consultation every year because facts have changed. And maybe before you weren't eligible for something, but now you might be eligible for something, right? And it's great to start the process of applying for something if you are eligible now while you still have DACA, and while you're waiting, to hear what the program, what's going to happen to the program. Next slide, please. All right, you could explore some possible options, right? These are some of the questions that you might want to ask, seeing yourself or seeing other family members, right? Maybe now you are married to a US citizen, right? Or a green card holder, see that could potentially qualify you for something else, right? Maybe someone in the past filed a petition for yourself or for your parents, right? Maybe your parents' brother or their parents filed for something on your behalf. See if that affords you any sort of immigration relief, right? If you were able to travel on advanced parole before that was taken away for DACA recipients, maybe that will afford you to, to get a green card or another form of protection, right? Have you ever been a victim of a crime? So there's questions that a legal representative could ask you to see if this would allow you to explore other options that would lead you to a green card. Next slide, please. And here are some resources where you could get information right now. Things are changing so rapidly. You know, between, you know, the program is here, the program is not, another court case has hurt the program, and it's hard to keep up. Also, a lot of times, news outlets don't always give us the complete picture. So it's important to go to trusted organizations and trusted resources to get information from them. Here I've listed a few organizations that are trusted that do a lot of work with documented individuals, as well as a link to organizations here in here in California who are offering fee assistance for you to look into. Next slide, please. And, you know, just a recap of it, if you're able to renew now. If you need fee assistance, please look into them. A lot of organizations are offering fee assistance right now. When you go in to renew your DACA, make sure that you get a legal consultation for potentially being eligible for other forms of relief, and stay informed. It's really important to stay, you know, informed as things move quickly, and also to see how you could get involved. You know, in the past, Congress has, you know, there's been bills introduced that would give more permanent status to this group of individuals. You know, they've been there, they've gone, and now as we're waiting to hear what will happen next, it's important to see how you can get involved to maybe, you know, motivate some of your representatives to bring that back on the table. So thank you so much. I will pass it now to Allison.
Thank you, Veronica. Next slide, please. So we're going to switch gears and talk about temporary protected status, TPS, which is another program unfortunately facing challenges and attacks by the current administration. Next slide. For those of you who may not be familiar with TPS, I'm going to give a brief description of the program and then talk about what's currently happening. So temporary protected status is exactly that. It is a temporary form of protection. It is only available to people from specific countries that have been designated by our government as a place that people should not be forced to return to, or where given conditions in the country they could not absorb people returning to the country. And these are usually related to different issues in the country. It could be a civil war, some sort of ongoing strife. It could be a natural disaster like a hurricane or a devastating earthquake, or it could be other extraordinary circumstances, you know, kind of political turmoil, something of that nature. So this is something that's existed in our immigration law for some time, but over the years, different countries are designated as TPS countries. Currently, about 300,000 people are registered in the current, in TPS from 10 different countries. And we'll talk about what those countries are and what the status of those designations and protections are. Okay, next slide. When someone registers for TPS, they get different benefits. In some ways, it's a little bit similar to the DACA program in that it provides protection. You have to renew it periodically, and it doesn't lead to any permanent status, but it does provide protection and some stability for folks who are registered. So TPS holders have the right to remain lawfully in the United States. They're protected from removal, meaning they can't be deported by the immigration authorities. They are granted a work permit while they are in lawful TPS status. That's also called an employment authorization document. We usually refer to it as a work permit. They can also apply for permission to travel abroad on advance parole. That's something that used to be available for the DACA program as well, but it's no longer a possibility, but remains an option for people who have TPS. So again, TPS is this kind of temporary designation that gets reviewed periodically. Usually it's a period of 18 months where people have to re-register for the program, reapply for their work permit, and then they have that work permit and protection for an additional 18 months, so long as the designation of their country continues. So let's talk about who's currently protected under TPS right now. Next slide, please. As I mentioned before, the US government has to designate which countries will be protected under TPS. They review these periodically. They can terminate a designation of a country. They do have to justify why they're terminating that designation, or they can extend the designation of a country for an additional 18-month period. They can also designate new countries at any point when something has happened that they believe the situation merits designation. So right now, these are the countries, these are the 10 countries that are designated under the TPS program: El Salvador, Haiti, Honduras, Nepal, Nicaragua, Sudan, Yemen, Somalia, South Sudan, and Syria. If you are looking at the slides right now, the countries in red on the left half of your screen, the Trump administration uh, announced that it would be reviewing TPS designations, and it issued terminations for those 6 countries. So the 6 countries in red on the left half of your screen: El Salvador, Haiti, Honduras, Nepal, Nicaragua, and Sudan. Those were terminated by the Trump administration. However, this is going to sound very familiar to what you just heard about DACA. There were several lawsuits challenging that termination, and therefore these programs still have TPS protection. I'll describe that a little bit more in a moment. But those, so the termination is kind of on hold while those lawsuits are pending in court. The 4 countries in the black font on the right hand of your screen: Yemen, Somalia, South Sudan, and Syria, still have TPS designation. So there was no termination of those protections, although they are being reviewed periodically, and we don't know about the redesignation of those countries coming up. So just to let you know, when we talk about that these are the countries that have TPS, it doesn't mean anyone who is a national of those countries is eligible to apply for TPS. When TPS programs are announced for certain countries, when our government designates a country a TPS country, it only is available to people who were already inside the US at the time of designation. So it's the idea here is the US government is always worried about inviting people to come to the country to take advantage of some immigration program. So they kind of always have a date where it's backward looking in time. So for an example, in the case of Haiti, there was a really serious, devastating earthquake in that country in 2010. And so when Haiti was designated as a TPS country, only Haitians who were already living in the United States as of the date of that designation could apply for protection under TPS. So at this point, there might be a few people who were here, but for whatever reason didn't apply during those initial designation periods. They may be eligible to apply as a late registrant for the program, but in general, most people are just now renewing their TPS status. So just to let you know, there are some limitations. This is not a program that's available to all nationals of these countries. Okay, next slide. So let me walk you through the current status of these 10 countries. So we said the countries who currently have active TPS designations are Syria, Yemen, Somalia, and South Sudan. Syria's designation was recently extended through March 31st, 2021. People should have already applied to renew, eligible Syrians should have already applied to renew their TPS designation last month. That period ran through late November and is now closed, although again, there are some exceptions for late registration. The fate of some of these other programs are a little bit up in the air. Yemen's designation ends on March 3rd, 2020, Somalia on March 17, 2020, and South Sudan on November 2nd, 2020. So we'll be hearing from the government about whether they will extend these designations or terminate them like they have for these other countries. They always make these announcements at least 6 60 days in advance of the expiration date of the designation. So for Yemen, we'll likely be hearing about that very, very soon. Same for Somalia, since those expiration dates are quickly approaching. But these countries are still designated and people still have TPS protections, but they do wait those 18 months to see if there will be granted an extension and can reapply for renewal for their TPS status and their work permit. Okay, next slide. Most people who have TPS are in one of these 6 countries that have actually been terminated by the Trump administration. The largest TPS country is El Salvador. There's over 200, almost 250,000 Salvadorans enrolled in TPS. There has been, like I said, terminations for these countries. There are different lawsuits challenging those terminations. And just last month on November 4th, the administration announced that given all of these different lawsuits, because they're required to hold off on formally terminating or ending these programs while the cases are pending, they are going to extend the TPS protections for all nationals of these countries until January 4th, 2021. So they just kind of did a more uniform extension for these countries, even though the courts are basically deciding whether the termination can move forward or not. This is a little bit different than extending the designation. The administration is saying, no, we still want to terminate their designation, but while the court cases are pending, we're going to allow these people to continue to receive the same protections under TPS. It's a little bit different than people who apply to renew their TPS status. And if we can go to the next slide, people from these 6 countries, their cases are just automatically extended. So they don't have to apply to renew, they don't get a new work permit, they're just automatically, there was an announcement published saying anybody who had TPS from these countries will be automatically extended through January 4th, 2021. So there's no need to file an application to renew. And unfortunately, people won't get a new work permit, which can cause some confusion. And what the government is saying is that they should print out the notice about the extension. That's in something called the Federal Register, where they kind of announce decisions by the administration, and they can provide that announcement to their employer to show that their current work permit is now valid through January 4th, 2021. And I've provided a link for you to that announcement in case it is useful to you or people you know or work with. So that's the current status of those 10 countries. Really, just like with DACA, the fate of the registrants for TPS from those 6 countries is a little bit up in the air. We know they're going to remain protected through that date in January 2021, but beyond that, it's unclear whether the administration will be able to move forward with the termination or if they'll be allowed to continue with TPS status. Next slide. So a big question on a lot of people's minds, especially from those 6 countries, is what happens to me if TPS ends? So even if there's a negative court decision, there is TPS status, or even if there's an announcement that they're going to terminate a country that's right now designated for TPS, anyone who has TPS status, their work permit and that status will be valid through the expiration date, even if there's some announcement either by the administration or by the courts about termination. So people should feel very secure that whatever their documents say or whatever extension they've been granted will be recognized by the immigration authorities and should be recognized by their employers. Again, if the government is going to terminate TPS, they usually provide at least 60 days notice. And that's true even if they're going to renew. They always provide at least 60 days notice, usually a little bit more. The recipients who are from countries that are part of these different lawsuits, they've actually specified even additional time that they would give notice to folks about a real final termination to that to those protections. And depending on on the country, it's anywhere from 4 to 12 months. They have said that they would grant a 12-month or 365-day kind of phase-out period for Salvadorans because that is the largest group of TPS recipients. However, when that designation, when that period of protection does end, that person is technically without status. Now, that doesn't necessarily mean that day they have to leave the country or that day immigration is going to try to deport them. People have the right to apply for other immigration benefits, protections, and statuses, and they have the right in almost every case to appear before an immigration judge before they can be deported and try to defend themselves against deportation and be granted some other form of status. So people have a lot more due process rights and rights to pursue other legal options than they may be aware of. So it's very important during this time of uncertainty that people figure out, what is a plan B for themselves, just like in the case with DACA recipients. If things don't go well with these court cases, if the administration is allowed to end TPS for one or more of these countries, people can still pursue other legal options here in the United States. Next slide, please. So again, getting a legal consultation is really important. We're going to sound kind of like a broken record on this webinar, but it's so important for people to talk to an expert, to take time to do a real deep and detailed consultation to really understand their situation and their options. Even if ultimately that person doesn't have any other good legal options, it's important that they know that they're empowered with that information. And like Veronica mentioned, your situation may have changed since the last time you got a consultation. You may have gotten married, you may have a family member in the military, you may have become a crime victim, and all of those things can potentially be help someone become eligible for an immigration benefit, or there may have been subsequent changes in the law since your last consultation that even though you weren't eligible before, you might be eligible for something now. All immigration processes take a time to be processed. All applications take time to be processed. It's a big bureaucracy. So people should start those processes sooner rather than later. We don't want to wait until someone's TPS is actually terminated or the DACA is actually terminated before they start applying for an alternative form of protection. Okay, next slide. So there's a lot of activism around protecting TPS. Some TPS designations have been around for over 20 years. And so there are people who have really spent their whole lives in the United States, their adult lives at least in the United States, and have really deep, deep ties to the country. And so they are looking for ways to either protect TPS or just like in the case of DACA recipients, kind of, to push for something in Congress that would provide a permanent solution to TPS recipients. So there's the National TPS Alliance that's doing a lot of advocacy in DC, pushing for a permanent solution. And then of course, there's other local groups that are engaging in that with local communities. We also have some updates on our website about some of the different timelines and processes that I just described if you're interested in more information. And then of course, USCIS always provides updates about those TPS designations, whether certain countries are going to be extended, what the deadlines for renewals are, things like that. So you can always check on their website also for that kind of firsthand information. At the end of the webinar, I'll provide you some information about where to go for legal services, how to pick a legal service provider, but I'm going to leave my comments around TPS there and turn it over to Ariel, who's going to walk us through some updates on public charge. So we can go to the next slide, please. Hi, Ariel. I don't know, we're having trouble hearing you. You might be on mute. Okay, I'm having a hard time hearing you, Ariel, so I don't know if you're having technical issues or something's going on. I'm going to go ahead and walk folks through some public charge basics, but please feel free to interrupt me if you're able to work out your technical glitch. So let's go ahead and talk about public charge, which is in the news a lot lately. There's a lot of confusion about what it is, and really a lot of misinformation out there about who it affects and what, how it might impact immigrant families. Next slide, please. So these are some of the ideas out there about what public charge is. You know, I get public benefits.
Allison?
Yes. Oh, great.
Oh, you're able to hear me?
Yes, wonderful. Okay, take it away,
Okay,
Ariel.
great. Sorry about those technical
That's okay.
difficulties.
I'm glad you're able to get on. Thank you.
Okay. Okay. Thanks, Allison. So on this first slide here, we just wanted to start by acknowledging the many questions and concerns that are wrapped up in this issue of public charge. You know, some people may be wondering if it means that the government will use information that they've submitted to public benefits granting agencies to find and deport them. Others are afraid that using public benefits or disenrolling their children from benefits, they think that that may be something that they need to do in order to continue to access benefits, or if they hope to obtain some sort of immigration status in the future, or they're concerned that use of public benefits might prevent them from becoming U.S. citizens. Next slide, please. So in reality, public charge only applies in two very limited situations. It applies when a person is seeking a visa to enter the United States, or if they're seeking a green card through a family member. And so those are the only two situations. Next slide. And so we really want to emphasize that public charge does not have anything to do with a person's eligibility to receive or use public benefits. Next slide. And it's also important to understand that a person must be coming forward and submitting an immigration application that has a public charge test as part of the eligibility requirements. Immigration officers are not going door to door looking for quote unquote public charges to deport. And if someone is found to be likely to become a public charge, what that means is that their application may be denied on that basis. The same way that an application could be denied for disqualifying criminal issues, or if a person has lied on an immigration application. Next slide. And then if you could advance the slide for more text on here. So what is, and yet again, please. So what's potentially changing is how some immigration officers think about this issue of who is likely to depend on public benefits in the future. Next slide, please. And next slide. So public charge does not affect all immigrants or all immigration situations. And in these next few slides, we are going to go through who it applies to. On the slide here, we have sort of a visual illustration of the many different types of immigration statuses. Each has different rules about whether and how long a person can live and work in the United States. For example, people who are undocumented may have come to the United States without permission, or maybe they had an immigration status, but it has since expired or it was taken away. People with DACA or TPS have temporary permission to live and work in the United States, but as Veronica and Allison already explained, they must ask for permission for this to be renewed every so often, and it's not a permanent form of status, nor does it have a pathway to permanent status. As you go up this pyramid towards the top, people have stronger protections to live and work in the United States, and U.S. citizens at the very top are the only ones who are completely protected from deportation. And because there are so many types of immigration status, public charge does not affect every person who identifies as an immigrant. So it's very important that people understand how public charge affects their specific situation before deciding to disenroll from public benefits. Next slide, please. And we also want to emphasize that many of the immigrants who were on that previous slide are not subject to public charge. This includes refugees and asylees, special immigrant juveniles, which is a special status for children who have been abused, abandoned, or neglected by one of their parents. And there also must be a dependent of a juvenile court. Public charge also does not apply to victims of certain crimes, what's called the U visa, or victims of human trafficking, which is the T visa. It doesn't apply when someone is either applying for DACA or renewing their DACA. TPS applicants are also not subject to public charge. Naturalization applicants, which is the application when someone who is a permanent resident or green card holder applies to become a U.S. citizen, also no public charge test. And then there are some others that are listed there on the slide of a bunch of other less common immigration statuses or situations that also are not subject to public charge. Also, most legal permanent residents or green card holders are not. And in a moment, we'll talk about when green card holders do need to worry about public charge. And U.S. citizens are not subject to public charge. Next slide, please. Actually, can we go back for a second, Alonso? So there was a little pink box that just popped up after I went through that entire list of people who, when they are seeking that particular status, they are not subject to a public charge test. However, some of these statuses either do not have a direct pathway to a green card, like DACA and TPS, or they do, but maybe someone, for whatever reason, decided to sort of switch tracks and seek permanent residency through a petition filed by a U.S. citizen or permanent resident family member. So if someone is applying for permanent residency through a petition where a U.S. citizen or permanent resident family member is petitioning or sponsoring for them to get a green card, public charge would apply. Okay, next slide, please. And so these are some common questions having to do with permanent residents or green card holders. They wonder if when they're renewing their green card, are they subject to public charge? Or when they're applying to become a U.S. citizen through the naturalization process, are they subject to public charge? Next slide. So in both those situations, there's no public charge test. Someone can renew their green card without having to worry about whether or not they are going to be scrutinized about their likelihood of being a public charge in the future. And the same has to do with if someone is applying to become a U.S. citizen. Next slide. So do green card holders ever need to worry about public charge? So the short answer is most of the time they do not. On this slide, we have two exceptions to that general rule. One is if a green card holder travels outside the United States and stays outside for more than 180 days on a single trip. The immigration laws say that if you stay outside the country that long, when you come back, you may be subject to these same sort of admissibility tests that otherwise they should have already passed when they originally got their green card. And then there's another different public charge test, which is like a way in which their green card could be taken away based on public charge, and it's very, very rarely applied. So most people don't have to worry about that either. Next slide, please. And I just saw a question sort of popping up about what is this concept of public charge, which we're going to get to in a moment. But we first just wanted to emphasize that most people don't have to worry about it. So here's some examples. One is Maya. Maybe she has a green card. She wants to become a U.S. citizen. So as I just covered, Maya would not have to worry about public charge because there's no public charge test to naturalize. Next slide. So another example would be Jesus, who has DACA, and he doesn't really have any way to get a green card right now. So he's another person who doesn't have to worry about DACA or doesn't have to worry about public charge because there's no public charge test for the DACA renewal. And we don't really know what other applications down the road he might be submitting and whether or not public charge would be part of that application. And yet another example, Chris is engaged to a U.S. citizen. Once they marry, that U.S. citizen is going to petition for them. So that is an example of a situation where someone would need to consider public charge. Next slide. And so what is the current status of public charge? Next slide. So now we're going to try and get to what public charge is. So the immigration laws, which is what Congress is the one who writes the immigration laws and the only one who can change the laws. And so currently immigration law says that a person can be denied admission or a green card if they are likely to become a public charge. Next slide. So the law does not define public charge, and that is what this current administration is trying to change. The current definition is a public charge is someone who is likely to become primarily dependent on the government for income support. And that means that they will rely upon either cash assistance or institutionalization for long-term care at government expense. So those are the only two types of benefits programs that if a person used one of those types of programs, or they were viewed as likely to use one of those types of programs in the future, they could be deemed a public charge. And on this slide, we have some examples of what cash assistance is. It would be the Social Security Income, or SSI, also TANF, Temporary Assistance for Needy Families, CalWORKS, or other general assistance programs. And then when we talk about long-term institutionalization at government expense, this is like a nursing home or a mental health institution paid for by Medi-Cal. Next slide. So there are many, many benefits that do not count as part of this public charge test. All of the programs listed on this slide, a person can use without worrying about any immigration consequences. Some of the programs on this slide, this current administration is trying to make count, but for now, nothing has changed. So any of the benefits that are on this slide, people can continue to use with no public charge effect. Next slide. And then also, if someone who is seeking admission or a green card, if their family is using benefits, that will not count against the applicant. Next slide. So now we have another example just to illustrate that point. Suppose that Laura is undocumented, but her children are U.S. citizens, and so they qualify for certain benefits, food stamps, other programs. And Laura, though, is worried about signing her children up for these benefits that they qualify for because of her own status. And so Laura's children's use of benefits will not affect her if later on she has some way to apply for immigration status. Also keep in mind that right now she's not subject to a public charge test because she's not submitting any kind of application. She's not coming forward or seeking admission. And depending on what kind of application she may down the road qualify and apply for, it's possible that it might be one of those that doesn't involve a public charge test, for instance, through a U visa or a T visa or some other situation. Next slide. So the immigration laws also tell immigration officers when they're trying to decide whether a person is likely to become a public charge in the future, that there's a variety of factors they have to consider. They have to look at a person's age, their health, education, employment history, whatever financial resources they have, how many dependents they have to support. So there's a bunch of factors that are listed out in the immigration statute. And so receipt of benefits is actually also just one piece of this whole inquiry. Next slide. And so as I mentioned before, this administration is trying to change the definition of public charge, right? They cannot change the immigration laws, only Congress can do that. But because the law simply says someone who is likely to become a public charge, but doesn't say what that means, this administration can try and reinterpret what it means to be a public charge. Next slide. So we also want to emphasize that for now, none of the changes to public charge have gone into effect. There's different changes that would apply in different contexts. On the first bullet point here, we're talking about cases that would be decided by U.S. Citizenship and Immigration Services. So that would be people with green card interviews here in the United States. USCIS, right, is the same agency that makes decisions on DACA applications and TPS applications. And so the changes that would influence how USCIS makes public charge decisions has been blocked nationwide, so across the country, by a couple of courts. There's multiple lawsuits. And so we would have to lose all of these injunctions, which is the court order that blocks the rule from going forward before USCIS could try to apply this new rule. So that's not happening for cases with USCIS. And then in addition, there are also changes similar to the changes that would, but are blocked, but that would otherwise apply to USCIS for cases decided at U.S. consulates and embassies abroad. And those also have not yet been implemented. In the case of the consulates and the embassies, it's not that any court has blocked them from going forward. It's just that they are waiting to finalize a form that will be finalized no later or no earlier than December 23rd of this year. So most of us assume that the earliest that at the consulates, potentially we would see these changes in the definition of public charge and some of those other changes would be in 2020. But there is a note here that the consulates and embassies already have a sort of more strict rubric for evaluating public charge, even though they have continued to use the definition of primarily dependent on the government for income support. Okay, next slide. So what should people do now if they're worried about public charge? Next slide. So first of all, we just want to emphasize some key points. One of the things is that public charge does not change who is eligible for benefits. And also, none of these new changes have gone into effect yet, although the consulates are already more strict, as I was just explaining. Also, benefits received by family members don't count, and public charge only applies in two situations: when someone is applying to enter the United States or applying for a green card through family. And many immigrants are not impacted. This would include VAWA, UT, refugees, asylees, and DACA and TPS folks would only be impacted if they apply for a green card through family. Next slide. So as Allison and Veronica have already been emphasizing, you know, we recommend that people get a legal checkup and have a consultation, and that they do this first before they make any decisions about receiving public benefits programs that may be critical to theirs or their family's health, safety, and well-being. So we have on the screen here a link to a national legal directory. You can enter in your zip code and find low cost or free immigration legal service providers in your area. And then there's also a list specific to California, which is that second link on this slide. Or you may also already know a trusted local legal service provider. Next slide. And then we also have on the screen some links to get more information and to also sort of stay on top of these changes with public charge, because they are continuing to fluctuate just because there are legal challenges and other things that this administration is trying to do to circumvent the legal challenges. So the ILRC, our organization, Immigrant Legal Resource Center, has a web page devoted to public charge. The link is there on the screen. There's also Protecting Immigrant Families, and then the National Immigration, well, actually, I'm not sure what it stands for, but NILC is also on that screen. Next slide. And next slide. And so now I'm going to turn it back over to Allison to sort of wrap up with some final next steps based on everything that we talked about, and then we're going to save some time for questions.
Great. Thanks so much, Ariel. So that was a lot of information in 1 hour. You know, there's so much going on and so many changes. And as you can see in those 3 areas we just covered, you know, there's a certain program, there's been a certain history. The administration has tried to kind of attack those protections or make certain standards stricter. Those get challenged in the courts. And so a lot of this is in limbo and it's kind of a moving target. So we're working really hard. Lots of other organizations and legal experts are working really hard to stay on top of these changes and to do advocacy to make sure that they never get implemented or they are improved before they get implemented. So it's really important to stay up to date, and I'm going to provide some links, and we've provided links in those in the specific issue areas about where you can go and get more information. You know, I would say that on the ILRC website, something I really like that we do is we have a community resources page, and that means there's information that's kind of more reader friendly, more accessible to the community, and we try to make things available in multiple languages. So if you need kind of shorter, more concise resources explaining some of these issues, even if you don't feel like you fully understand it, but you want to kind of make them available to people you work with, students, colleagues, people in your family, you know, that could be a really helpful thing to do, because we do know it's hard to stay informed when so much there's so much movement on these issues. I'll say it one more time just to reinforce it, is getting that one-on-one legal consultation is really, really helpful to understand someone's individual situation and their legal options, and really to know how some of these changes are gonna can affect an individual person and their family. You know, we're hearing really terrible stories about people, even people with green cards, canceling their kids' Medi-Cal, canceling food stamps that their children get because they're so fearful about this public charge change, when in fact they don't need to do that, right? So as Ariel mentioned, you know, the benefits your family members don't count against you. And if you have your green card already, you're entitled to those benefits and you aren't subject to public charge anyway. So that misinformation is translating into really things that have really negative consequences for the well-beings of our community. So it's really important people get good information so that they can make the best choice for their family. We also need people to participate, to stay engaged. So not just following what's happening, but also trying to shape what's happening. So we hope that you'll engage with some of the organizations we highlighted throughout the webinar, whether it's local advocacy, state advocacy, or federal advocacy, to really make sure the laws really address the needs of the community, the reality on the ground. So let me go, let's go to the next slide. You know, you heard a little bit about some of these different options out there that are available for people, and that DACA and TPS folks might need to think about some of these other legal programs. And I don't want to go through all of them, but I just want to highlight, you know, that the immigration law is a really complex area of law, and there's lots of different programs that really are specific to somebody's individual case history, and that's why that legal consultation is so important. So we know there are special programs for military families, for domestic violence victims, people who have been victims of serious crimes and have cooperated with law enforcement, trafficking victims, either forced labor or sex trafficking victims, people who fear being persecuted in their home countries, special immigrant juvenile status, again, for youth who have been abused, neglected, or abandoned, particularly thinking about youth in foster care. They may have a pathway to a green card by virtue of their family kind of situation. And then there's kind of employment-based options that might be available to some folks too. So to just, even though we focused on these kind of what we considered to be hot topics, where we could provide important updates, there's a lot going on in immigration law, and only through that one-on-one consultation can somebody really understand what might be a fit for them, what might be a pathway to status for them. Next slide. And I just want to say one kind of word of caution. Even though we're encouraging people to get consultations, we really have to watch out for immigration fraud. That's a big problem. I know where I live in the Central Valley, it's rampant, and we really have to help people connect with quality legal service providers. There's a lot of investment being made right now by the state of California, by private foundations, to provide more legal services to the immigrant community, and we hope that that will make an effect when people have good providers available to them for low or no cost, that they won't become victims to these fraudulent service providers. But just as a reminder, in the state of California, only licensed attorneys, or what are called accredited representatives, can give legal advice in immigration cases. Accredited representatives are non-attorneys who have gone through significant training and have received certification from the Department of Justice to provide representation and legal advice in certain kinds of immigration cases. So really only attorneys and accredited representatives should be providing that kind of legal advice, and we really want to warn people against getting legal advice from folks that are notarios, are notaries, are immigration consultants, tax preparers, things like that. Even folks who have really good intentions that want to help the community, people that can provide forms, they can provide translation services, they can notarize documents, but providing legal advice and representing someone in a legal case isn't something they're actually allowed to do in the state of California. And so just kind of some best practices when seeking a legal service provider. A quality provider will always provide a contract, or what's called a retainer, saying this is what I'm going to do, this is what you're going to do as the client. If there's any fee associated with that, it will be disclosed. If you do make a payment for any assistance, they should give you a receipt for that. Everything should be documented. They should explain the process to you. This is what the options are. What do you want to do? You make kind of a plan for your case, and then you move forward. They answer your questions. Obviously, we aren't in charge. Those of us who work in immigration law, we're not in charge of how a case gets decided or how long the bureaucracy takes to decide on a case, but you should understand what's happening in your case, what the plan is, and what the ultimate outcome, the goal is for that case, and maybe what some of the challenges might be for your case along that path. And most importantly, a legal service provider should follow the rules. Anyone who says that they can do an express service, they have contacts within the immigration service, things like that, or really is charging an exorbitant amount, that's really a red flag, and people should get a second opinion. It's like going to the doctor. If you get a very serious diagnosis or someone recommends a course of action that sounds really unusual to you, get a second opinion. It's your right as a consumer. It's an important process that you're entering, and so we really want to make sure people feel really confident in the person they're getting legal support from. Next slide. I think Ariel kind of already flagged this for you, but just one more time. There is a national directory of legal service providers that's searchable by zip code. These are nonprofits that provide free or low-cost services. And then here in the state of California, we're very lucky. Our state has made a big investment in legal service providers, and also in providing legal fee assistance with the DACA renewal application costs. That's the California Department of Social Services, or CDSS, and they have a link to those organizations that they're providing funding to. So that's a great resource, because it's providers throughout the state of California. But then also some of the investment coming from the state is to provide services directly on our college campuses. And so I urge you to connect with the local resources that will be available to you on your campus and in your local community. Okay, next slide. I'm going to stop there so we have time for your questions. We're looking forward to hearing if there are kind of follow-up questions about some of the topics we've covered, or if there are new issues we didn't address that you'd like to know more about. So I'm going to ask Alonso to kind of help us sift through some of the questions that have come through on the chat box.
Yeah, so one of the questions is in regards to under which circumstances can an individual's DACA be terminated by ICE or USCIS?
Hey, so I could take that. This is Veronica. So there are certain, charges and convictions or contact with law enforcement that might make someone ineligible for DACA. I think a common example would be DUI, where, driving under the influence and your DACA was terminated in that case. If people who are able to change a charge from a DUI to maybe something lesser, like a wet reckless, might still be eligible for DACA. In that case, would be able to see if they are able to reapply now. Also, if it was found that maybe something was missing and they weren't eligible for DACA to begin with, it could be terminated in that instance. But now there might be more supporting documents that they could submit. So it's granted and then terminated. I don't know if any of Ariel or Allison would like to add something to that.
No, this is Allison. I agree with that. I think criminal convictions is the most common way someone would have their DACA terminated. Leaving the country, departing the United States without advance parole would also make your DACA, cause your DACA to be revoked. But I would say the most common thing we see in the community is criminal issues, and the DUI, I would say, is the number one thing. One DUI makes you ineligible for DACA. So if you had a DUI, you may not have applied for DACA to begin with, but if you currently have DACA and you get a DUI, your DACA can be revoked. So I would say that's the most common scenario and really tragic. So it's important people understand the repercussions of that.
Thank you. There's an additional question on DACA. If it's terminated, what are the requirements for an individual after the work permit is expired?
So if your DACA is terminated and you are unable to apply, for DACA because you're disqualified, then once your work permit is expired, then you're, out of DACA status in that sense, and then you wouldn't be able to get a work permit again under DACA. Definitely, explore other options of whether you qualify for another form of relief that would allow you to get a work permit in that way, or see if there's information to alternative work options for someone who would be who wouldn't have a work permit. They're definitely out there. One of the links that I posted from the organization Immigrant Rising, I know they have a lot of information for alternative employment options that an individual could look into.
Thank you. This question is related to TPS. The TPS status from the 6 countries listed in the slides before, how are they being informed that they just need to show the announcement of the automatic renewal?
That was announced by the government. I'm not sure if every TPS recipient did receive notification of that. It's likely that just because people track the status of their country's designation that they would have seen that, but I'm not sure if people were individually informed of that by the immigration service. So there could be folks out there that still think they have a termination or a expiration date much sooner that is what's on their work permit and not this new January 2021. It's very possible. Even if someone were to receive a notification, if you've moved in the interim since the last time you renewed TPS and you didn't update your address with CIS, it would be possible that you wouldn't have received it anyway. So there's lots of scenarios in which someone may not be aware of that.
Thank you. An additional question on TPS. If someone is fired from their job because of the expiration date on their work permit, what kind of options do they have?
That's a great question. So we do see a lot of issues come up in terms of employment rights in both the TPS and DACA scenario. So the TPS stuff is particularly confusing because, you know, as we were talking about, someone's actual card, the work permit card itself, has a certain expiration date, and then the government's saying, oh, take this announcement from us and show it to your employer, and the employer may not be familiar with that or may not believe the employee about what the significance of that announcement is. So as a first matter, an employee should do that and try to resolve it directly with their employer. They should encourage their employer to seek legal advice if they have some doubts about the validity of that kind of whole scenario. If someone is actually fired or there's repercussions taken against them for that reason, they should seek legal assistance from an employment law specialist. One of a really strong nonprofit on these kinds of issues, kind of at the intersection of immigration and employment law, is Legal Aid at Work, and they've done a lot of work around TPS, DACA recipients, folks who have these kind of strange forms of protection and weird kind of expiration date issues with their employment authorization documents or work permits. So Legal Aid at Work would be a great resource. My understanding is on their website, they have information about different legal clinics in different parts of the state where you can go and have a consultation. And they also, I believe, have a hotline that you can call to ask questions and get more information. So maybe I can share that link with you, Alonso, to share out with the different participants.
Yeah, thank you. That would be great. We will follow up with everybody with links to, with this PowerPoint presentation, as well as a recording and additional contact information for myself. But we're going to go ahead and continue on with the questions. We have about 10 minutes or so left, and I apologize if we don't get to all of them. We'll try our best to get through these as quickly as possible, but thank you for asking such great questions. As we move along, more so related to public charge, some families are concerned, indicating on FAFSA that they're undocumented, or the DREAM Act that they receive cash assistance. Any suggestions on how to do that process?
But this is Ariel. So California has a lot of protections about information sharing, and so I know that this applies to lots of benefits applications submitted to public benefits granting agencies, and I would imagine that that also applies to like a FAFSA application. I don't know, Allison, if you have anything else to add.
Yeah, I don't think it would be a problem. You know, an undocumented student wouldn't be filing a FAFSA, right? They'd be filing for the DREAM Aid in California. But on a FAFSA application, if there's undocumented family members or folks are receiving benefits, it's really an income analysis. So we haven't heard about that information at all being shared with immigration or being used against applicants in any way. And receipt of financial aid in itself is not a problem for public charge. That's not one of the benefits that would count against someone for public charge. So in every way, I really don't think financial aid is going to be an issue for kind of just broader immigration issues or immigration enforcement, or for the public charge issues specifically.
Thank you. There was a recent announcement on the proposed renewal fee increases. Do you have an update on what that looks like?
Yeah, so there is a proposal to increase application fees for lots of different immigration applications and processes. And that proposal also includes eliminating the possibility of getting a fee waiver for lots of kinds of applications. And that is only a proposal. It's not in effect right now. and so the government is receiving public comments from the public now through December 30th about that proposal, and a lot of people are working really hard to show that that was going to be really, really negative, that if people are eligible for benefits, there needs to be reasonable fees and access to fee waivers so that they can secure the protections and the immigration statuses that they're eligible for. But one of the changes in that proposal is right now to apply for DACA, the DACA application itself doesn't have a fee, but then people pay $495 for their work permit. And under the new fee structure, it would change a little bit. They would now charge for the DACA renewal application, it would be $275. And then the work permit application would be $490. So that is a pretty significant increase in what the DACA renewal process would cost, especially when you consider that a DACA case is only valid for 2 years. So 6 months more or less before the expiration date of the 2-year period, you apply to renew. So if, increasing fees for something when it's only valid for 2 years, people are already not getting a lot of bang for their buck for $495. It's only valid for 2 years. So raising that by having this $275 fee for the DACA renewal and $490 for the work permit is going to create even an additional burden. What we hear in the community is the filing fee, the current filing fee, $495, is one of the main obstacles to people for renewing their DACA and prevented a lot of people from ever applying for DACA in the first place. So if it's already had such a chilling effect on the application rates for DACA eligible folks, imagine if this fee increase goes forward, we would think that impact would be even greater. So that's a proposal. Again, they're receiving public comments through the end of this month, December 30th, and then it'll probably take a few months for them to decide, review those comments, review the rule, and they have to justify if they are going to issue this new rule and new fee schedule, how they considered some of these public comments. So it's something we might that might go into effect in the new year, but it would be several months from now. So if people are renewing their DACA now, that's another reason to do it. Not just the looming Supreme Court decision coming likely in late spring 2020, but also the potential fee increase.
Thank you, and I think we have time for 1 or 2 more questions. And this we'll go with, for anyone that is undocumented and needs to have fingerprints or a background check, what is the impact on them? Can you share a little bit of insight on that?
So there's different kinds of background checks that people do. So for us here in California, for example, if you want to do a criminal background check, that's through what's called the live scan process, and that's run through the California Department of Justice. That information stays in California, and there's no kind of impact on immigration having access to that information. So that's a California kind of criminal background check. That's the live scan. Other folks might need to do a federal background check, and that's to see if they have a criminal record in multiple states, or if they've had contact with any federal agency, and that would include the Border Patrol, or what's called CBP, Customs and Border Protection, or ICE. That is a background check that is done through the FBI. And you send your fingerprints and a simple application. It costs $18, and they will send you your record with any federal agency or other criminal arrest that you've had in different states. It doesn't provide detailed information like a state background check would, but it provides kind of an overview. And it's often done to figure out if there was an issue with the Border Patrol or ICE. To date, that has not been an issue for people. People do it all the time, and they've done so safely, and it's actually a very important thing to do before applying for certain kinds of benefits. Sometimes people were stopped at the border, and they aren't sure what happened. They don't know if they were actually deported, and to kind of unpack what happened there, or to even get a case number from a prior case that they may have had. That's kind of the first step we do in kind of pulling a case together and figuring out what someone might be eligible for, or if it's risky for them to move forward with the case. So to date, we haven't seen that be a problem, and it's something that can be really, really vital to do. So for now, we would say we encourage people to do so. And then one last thing is you can also do requests under the Freedom of Information Act, or FOIA, and that is a law that allows you to have access to your own file of any federal agency, so you can get your records from different immigration-related agencies like USCIS, like ICE, like the Border Patrol, like the Department of State, or the Immigration Court, which is housed under the Department of Justice.
So a follow-up to that, so a student without a social security number can complete a background check for an internship?
Let's see, a background check for an internship. If that would be a criminal background check in the state of California, they would have to show some form of photo ID in order to get that background check completed. A couple of tips about that would be there's different places where you can go and do the live scan process if we're talking about a California background check. Some of those places are sheriff's departments or police departments. If undocumented folks, I suggest they go to private businesses rather than law enforcement agencies for that process. So sometimes UPS stores or like copy stores, they also provide a fingerprinting service and live scan service. And so it's probably preferable for undocumented people to go to one of those agencies rather than a law enforcement agency. One other tip when you're doing your FBI background check with the feds, you can put a different mailing address on your application if you do have some fear about what might be in your record. Again, it has been a safe process to date, but you can put an address of a friend or family member or even your legal service provider on your application rather than putting your home address.
Great, thank you for that information. And I think we're about time, and I apologize that we didn't get to all of the questions. We do have a transcript of the questions that were answered and those that were not. We will reach out to our partners at the ILRC to hopefully, and they can provide some additional answers that we can share with you all following this webinar. But I do want to thank everybody that took the time to join in, and I hope this was informative. The recording, as well as the PowerPoint slides and any of the additional information that was discussed in this webinar, will be available within the next 48 hours. Please see, there will be an email from me. So if you don't receive that, please definitely reach out on Monday. As well as if you have any additional questions, you can reach out to me here at the foundation, and we can make sure that our partners have any of the information that you're requesting. Any closing thoughts from our partners?
Thank you so much for the invitation and for everyone's participation. We know it's a busy time of year. We appreciate you tuning in. We hope it was helpful. Feedback you have would also be welcome, as we hope to provide you more updates like this in the new year. So thanks, everyone.
Thank you, everybody. Have a great rest of your day.